What not to say to the judge in a custody battle in Tulsa. We get many questions about what not to say to the judge in a custody battle. Tulsa County judges hear custody disputes every day. They are primarily focused on one issue: the best interests of the child. Parents who appear angry, unreasonable, dishonest, or unwilling to support the child's relationship with the other parent may unintentionally damage their own case. If you are involved in a custody dispute, here are some things you should avoid saying to the judge. My child gets to decide where they want to live. One of the most common misconceptions in Oklahoma custody cases is that a child can simply choose which parent they want to live with. While a child's preferences may be considered in certain circumstances, the judge makes the final decision. Oklahoma courts evaluate numerous factors relating to the child's best interests, and a child's preference is only one factor among many. Parents who insist that the child alone should determine custody may appear to misunderstand the court's role. I don't care what the other parent wants. Statements like this can raise concerns about a parent's willingness to co-parent. Judges generally favor parents who demonstrate a willingness to encourage a healthy relationship between the child and the other parent whenever it is safe and appropriate. A parent who appears unwilling to communicate or cooperate may create concerns about future parenting conflicts. The other parent is a terrible person. Courts want evidence, not insults. Rather than making broad attacks on the other parent's character, focus on specific facts that affect the child's welfare. Unsupported accusations often make the accusing parent appear more interested in personal grievances than the child's best interests. If there are legitimate concerns involving abuse, neglect, substance abuse, or other dangerous behavior, present evidence and testimony rather than emotional conclusions. I will never let the other parent see the child. Unless there are serious safety concerns, statements suggesting that a parent intends to interfere with visitation can be extremely damaging. Judges generally expect parents to comply with court orders and support the child's relationship with both parents. Threats to withhold visitation may suggest that the parent is placing personal feelings above the child's needs. I don't have to follow the court's orders. Few statements are more damaging in a custody case. Even if a parent disagrees with a court order, the proper course is to seek modification through the legal process. Openly admitting that court orders have been ignored or intentionally violated can severely affect credibility and future custody determinations. The child doesn't need the other parent. Oklahoma courts generally recognize that children benefit from meaningful relationships with both parents whenever possible. A parent who minimizes the importance of the other parent's role may appear unwilling to foster a healthy co-parenting relationship. Judges often view this negatively unless there is credible evidence showing contact would endanger the child. I don't have any proof. Custody cases are decided on evidence. While honesty is always important, parents should understand that allegations unsupported by evidence may carry little weight. If concerns exist regarding the child's safety or welfare, documentation, witness testimony, photographs, communications, school records, medical records, and other evidence can be critical. The case is really about getting back at my ex. Most parents would never say this directly, but some testimony effectively communicates the same message. Judges are skilled at recognizing when litigation is being driven by anger, revenge, or personal disputes rather than concerns about the child. The parent who remains focused on the child's needs often presents the stronger case. What judges want to hear. Rather than focusing on attacks against the other parent, successful custody presentations often emphasize the child's needs. Stability and consistency. Educational opportunities. Physical and emotional well-being. The parent's ability to provide a safe home. Willingness to encourage a healthy parent-child relationship. Compliance with court orders. Judges are looking for parents who place the child's interests above personal conflicts. Contact a Tulsa child custody attorney. What you say in court matters. A single statement can affect how the judge views your credibility, judgment, and ability to act in your child's best interests. Proper preparation before a custody hearing can help you present your case effectively and avoid mistakes that may harm your position. For a free consultation with an Oklahoma family law attorney at Kania Law Office, call 918-743-2233.